break. Okay, so the next thing we're going to talk about is the type of restriction that the government has imposed on your right to speech. It can be a state law, it can be a local ordinance, it can be some kind of policy, it can be an action that a police officer took in responding to a complaint, that sometimes there is something that brings the issue of the First Amendment protection of my right to speech versus something that the government did that infringed on my right to speak. And the courts make a distinction. They look at what that restriction was. Was it content-based or was it content neutral? And this is a very important distinction, because when a court is evaluating the situation, or even before it gets to a court, if we're dealing with a police chief or a city manager or a city attorney about some First Amendment public evangelism issue, they're going to do this legal analysis. Number one, is it protected speech? Well, that's an easy one, that, presenting the gospel is protected speech. Number two, what is the nature of the forum? Are we dealing with a traditional public forum, or are we dealing with a non-public forum, or are we dealing with private property? There's three things that they look at. Is it protected speech? Is it a traditional public forum, or what kind of forum is it? And then, is the restriction content neutral, or is it content based? And so once the court goes through that three-step analysis, then the court knows what type of legal standards apply. And so for something to be a content-based restriction, it can be content-based because it restricts a particular viewpoint, a particular message that you want to present, or it could be what's called topic discrimination. And here's what the difference is. If the government said, for example, we're not going to let you preach that Jesus Christ is the only way to heaven. That's a specific message that they're saying, we disfavor this message. And so that would be a content-based viewpoint discrimination. Or even if they said, you cannot say that any other religion is a false religion. You can't say that your religion is right and any other religion is false. We're not going to let anybody do that. That is viewpoint discrimination. That is saying that you have a message that the government is trying to censor. That is a disfavored message. That would be a content-based restriction. On the other hand, if they said, we're not going to let you talk about religion at all. We're not going to let anybody talk about religion. Now we're even-handed. We haven't said anything about one particular viewpoint or another particular viewpoint. Well, let's just avoid the whole topic of religion. That's not viewpoint discrimination, but it's topic discrimination. The government does not get to say what topics can be discussed and what can't. If they're drawing a line based on what it is that you're talking about, that's a content-based restriction. If they have to look at what you said in order to figure out whether you have violated their policy or haven't violated their policy, it is a content-based restriction. And for a content-based restriction, the legal standard is what in constitutional law is called strict scrutiny, and that is the court has to say that that restriction on your right of free speech is invalid. It's unconstitutional unless they find that it is necessary to serve a compelling state interest and that it's narrowly drawn to achieve that end. Okay, that's a legal standard, and I don't expect you all to be lawyers. Here's what you need to understand about that. A content-based restriction on speech is almost always going to be held unconstitutional. That's kind of the bottom line. Here's a quote from the Supreme Court: "Content-based regulations are presumptively invalid." That, you know, the government that's trying to justify that restriction, that law, that ordinance, that action of a police officer against you, they're going to have a steep uphill battle to get beyond a constitutional challenge. So that's strict scrutiny. There are in the booklet, I go into a little more depth with that, and you can read about it. And there have been some exceptions to that rule, but generally, if it is a content-based restriction, it's going to be held invalid. There was a school back in I think it was in the late 1960s, that enforced a part of a dress code. They would not let their students wear a black armband in protest of the Vietnam War. They didn't outlaw or they did not give any restrictions to any other kinds of protests, but they said, well, nobody can come to school with a black armband on because we're not going to allow that. And the court said, well, that was a content-based restriction. If you had said nobody's allowed to make any kind of protest, or you want to establish a dress code for your students and they have to wear a uniform, that's different. But if you say you can't do this that is designed to present a particular message, then since you're outlawing that particular message, that is a content-based restriction. And so the court said it was unconstitutional. So it's very important to determine, or the analysis of whether something is content-based or content-neutral is critical in a constitutional analysis of a First Amendment problem. If the restriction is content neutral, if it wasn't based on the content, if it just applies generally no matter what the message is, if it's a content neutral restriction on speech, then the court imposes what's called intermediate scrutiny. It's not as hard of a test. It's a little bit more involved, a little more wordy, more complicated maybe, but it's not as strict of a test. And it's very common for a content neutral restriction on speech to be upheld as a constitutional restriction, as not violating the First Amendment. So in order to pass intermediate scrutiny, a content neutral regulation or restriction on speech has to be a reasonable time, place, or manner restriction that's narrowly tailored to serve a significant state interest and leaves open ample alternative channels of communication. So you can see there's several parts to that test. It has to be reasonable. It has to be just based on time, place, or manner, which is what makes it content neutral. For example, the volume of speech, of noise that you're making. There are noise ordinances that very often usually are considered content neutral because they're not saying anything about what the message is. They're just saying about what the level of noise is. Well, that's going to be a content neutral restriction. And so then they say, okay, well, you've got a content neutral restriction and it's just dealing with time, place, or manner. It says during these hours you have to be under this decibel level, or there are different restrictions that they include. Those are time, place, or manner restrictions. And the courts, in viewing the state interest, the government justification or the result that they're trying to deal with is noise abatement, noise pollution. We want to control the amount, the level of noise. The courts have routinely said, well, that is a legitimate, significant state interest. And so then what's left is, did that restriction, was it reasonable and narrowly tailored to accomplish that governmental goal, and did it leave open alternative channels of communication? And so that's the analysis that's typically done with a noise ordinance. It's very common for noise ordinances that have been challenged on First Amendment grounds to be held, they're constitutional. But there's many exceptions to that, and a lot of times a noise ordinance is held unconstitutional. And sometimes one court looks at an ordinance and holds it unconstitutional, and another court looks at an ordinance that's worded almost exactly the same and says, well, that is constitutional. And so it's a difficult area of the law. There's a lot of gray area in it. But anyway, this intermediate scrutiny is what's applied to a content-neutral ordinance. Now, we had a state law in Florida that restricted the level of sound that can be emanating from a vehicle on the public streets and highways. And that so far sounds like a content-neutral restriction on speech. That's going to include all kinds of speech. When you're restricting noise, some of the noise that you're restricting is speech, and so the First Amendment is involved. So they had this ordinance, or this state law, that said you couldn't emit loud sounds from your boombox in your car, but it said that there were exemptions for political and commercial vehicles, that if you have the ice cream truck coming down the neighborhood, we're going to let them play their music and use their loudspeakers. And if you have, for a political campaign, you have somebody driving around and emanating speeches from their vehicle, we're making exceptions just for them, but for everybody else, we have this sound restriction. And the Florida Supreme Court said that was a content-based noise statute because it made an exception for certain types of speech, based on the content of their speech, and it applied to other types of speech. And so if they say music has to be regulated and religious proselytizing has to be regulated, but political speech and commercial speech doesn't, then you can see that there's a difference. There's a restriction of one that's exempt from the statute based on content, and the statute applies to the others, and the court said that's unconstitutional. So sometimes a noise ordinance is unconstitutional because of the exceptions that it allows, and there have been many noise ordinances that have been held unconstitutional because of the exceptions. And same thing with sign ordinances. They'll have a ordinance or a law that says you have to certain signs have to meet certain criteria, and you have to get a permit, and you have to do this and that, and this is how we're going to regulate our signs. But then they'll have one standard for political signs, and they'll have another standard for another kind of signs, and another standard for another kind of signs. And so the restrictions that somebody's speech on a sign is subject to ends up being depending on what the content of the message is. If it's a political message, then it has to meet some criteria, and if it's a religious message, it has to meet another criteria. And if the court is drawing lines, or the legislature is drawing lines and making distinctions based on the content, then it's a content-based restriction, and the court is almost always going to say can't do it. It's unconstitutional. So we have that. The other way that a noise ordinance is often held to be content-based is sometimes the terms in the ordinance itself, where it prohibits, for example, unnecessary and disturbing sounds, or unnecessary and annoying noise. And well, who decides what's necessary or not, or who decides what's annoying or not, And some of the courts have looked at language like that, and even though it's not talking about a particular message or a particular class of communication, such as political versus religious versus commercial, it's not making those distinctions, but it's restricting unnecessary and annoying noise, and it's not restricting other noise, and the courts have said, well, somebody's making a determination based on content, and so therefore it's a content-based ordinance, and therefore it's unconstitutional. Or they go through, there's another step they go through, but the end result is always going to be, or almost always going to be, it's unconstitutional. So that's how that goes. Sometimes, and I should say this too, regarding noise ordinances, sometimes they are, even if they're content neutral, they don't pass the intermediate scrutiny test. I'll go move my slide back. Sometimes they don't pass the test because they're so restrictive that they are not narrowly drawn, and they're not leaving open, ample alternative avenues of communication. It's so restrictive that it's basically shutting down communication. Then the courts have said, well, even though it's content neutral, we're holding it unconstitutional because even a content neutral restriction has to pass these other tests. And so there's a park across the street from the White House in Washington, D.C., and there was a content-neutral noise ordinance that said that noise in that park, or the ordinance that applied to that park, that the noise measured from a certain, I think 25 feet away, couldn't be over, I don't remember, I think it was 60 decibels. And that was a park that was commonly used for public protests. And the court said that it was content neutral. It had nothing to do with what people were saying or what message they were trying to get across, but that it was not narrowly tailored to accomplish the state's interest or the district's interest in noise abatement, because it's not reasonable that it restricted too much speech. It was overly restrictive, and so therefore it was unconstitutional. And there's other, we talked about noise ordinances. There's other restrictions that apply that have been held to violate one or more of the elements of this intermediate scrutiny test. Here's an example. There was down in Miami, there were people that were going to be protesting some event. I don't remember what the event was. And the police down there, they knew they had to allow these protesters to be there and do their protest. But they wanted, for whatever reason, they didn't want the people that their protesters were trying to get their message to be in any way interfered with. And so what they did was they had all the protesters in this park, and the police made a cordon. There were I don't remember how many officers, but bunches of officers, and they were basically arm in arm making a human shield to keep the protesters away from they kept them not only away from the people they were protesting, they kept them far away from the people that they were protesting, and so that they weren't able to get their message across at all to their intended audience. And the court held that that did not leave open ample alternative channels of communication. That restriction that the police imposed completely shut down that protest, or that message from getting from the protesters to the people they were trying to reach. A similar result happened in San Francisco when there was an event, and there was this group called the Peace Navy, and they were protesters in little boats, and they wanted to go to this event from the water, and the Coast Guard kept them at such a far distance from the event that the court held that action of the government was unconstitutional, because they succeeded in completely preventing the protesters from getting their message across. And so that was overly restrictive and didn't leave open ample alternative channels of communication. So we go into more detail with all of that in the book, and I'll be glad to talk to anybody about that in more detail and answer further questions. But that's basically how that works with content-based restrictions.